We actually do have another email question that came through during the break. Guys, put it up from Marissa. What if I wasn't wearing a seatbelt at the time of my accident? Can I still recover damages? Marissa, that's a great question.
Yeah, Marissa, you can. There may be an issue of comparative fault. The state of Florida has, again, the last couple of years has recently changed their laws to where if you are deemed to be more than 50% at fault for your injuries or for a wreck, then you cannot recover anything. It used to be you could be 75% at fault and you could still recover 25% of your damages. But the law changed a couple of years ago. If you are more at fault than the other person, you can't recover anything. When you start talking about comparative fault, it's what did you do to contribute or cause your own injuries? And so you may be driving down the road, you didn't do anything wrong, somebody ran a red light, they T-boned you, but you're not wearing a seatbelt. If the defense can show that your injuries would have been prevented or lessened by you wearing a seatbelt, then they can argue that as a element of comparative fault, and it can hang a percentage of liability on you, which you cannot recover from that driver. Right. So it factors in. I mean, you're supposed to wear a seatbelt. It's the law in the state of Florida. I know a lot of people don't like to wear them. But
you should.
You should.
You should.
But yeah, you absolutely can have that count against you if a seatbelt would have made a difference in the severity of your injuries.
Les, before we go to our second break, we get asked all the time, whether it's in the gas stations, grocery stores, and even when people come in to talk to us about their cases. If I file a claim, does that automatically mean that I am going to be suing someone and have to go to court?
Right. And the answer to that is no.
Right.
You buy insurance to protect you from mistakes and from accidents and from the unknown. Most claims, the vast majority of claims that we handle do not even have to, they never see the light of a courtroom.
Right.
They never even make it, they don't even get filed. It's a small percentage and usually there's a reason why you have to file a case. It could be that the damages are very complex. It could be that there's a liability dispute, a he said, she said. It could be that the insurance company that you're dealing with, which is usually who we are dealing with, they just have an unrealistic view of what we think our clients' damages are. Sometimes you get clients that have expectations that are a little out of whack, but I don't think we have to deal with that very much. Most of the time we have to file suit. It's something we have to file because the other side is just saying, nope, we're not buying it.
Right. And we're protecting our client.
And so we're going to protect our client. We're going to file suit and we're going to put it through the discovery process. But most cases will resolve without having to do that.
But filing a claim on someone's insurance policy is not the same thing as suing.
It's not the same as suing, no.
No, absolutely not.